After a no followed by a yes and then another no, board exams for classes 5, 8 and 9 in Karnataka are now postponed. The Supreme Court has intervened once again, this time halting the ongoing board exams for classes 5, 8 and 9. The rollercoaster ride began with a single judge bench of the Karnataka High Court quashing the state government's decision to conduct common assessments for these classes, citing procedural lapses. This decision set the stage for a legal battle with the state government, quickly appealing the ruling. However, just a day later, a division bench of the same court stayed the single judge judgment, giving the green light for exams to proceed as scheduled. This interim decision witnessed a range of reactions from stakeholders. While some welcomed the prospect of exams continuing without disruption, others voiced concerns regarding the legality and fairness of the process. After hearing an appeal filed by the Registered Unaided Private Schools Management Association in Karnataka against the state of Karnataka, the Supreme Court stepped in, setting aside the division bench's order and putting the exams on hold until further notice. The said examinations held pursuant to the notification deemed illegal by single judge should not have been held, affecting the exam system and the career of the students. Needless to clarify that the exam shall not be proceeded with further, said the apex court. You have spoiled the entire education system of the country and now you want to complicate it. Please do not do that, the top court told the Karnataka Government Council. While some welcomed the Supreme Court's decision, citing concerns about the mental well-being of students and the validity of board exams for these classes, others disliked the continuous back and forth which has disrupted the academic calendar and caused logistical challenges for schools.
As you know, we have prevailed before the single bench, which declared that notifications pursuant to which the examinations were to be conducted were to be struck down. Okay, and assailing that the single judge's order, they went on an appeal, and through an interim order, the exams were directed to be conducted. Assailing the interim order, we had approached the Honorable Supreme Court. We argued it before a bench presided by Justice Bela Trivedi, and Justice Mr. Pankaj Mittal. And the same arguments as canvassed before the single judge came to be advanced before the division bench of the Honorable Supreme Court as well, which says that none of the legislative mandate as prescribed under the Karnataka Education Act and also the Right to Education to Free and Compulsory Education Act of the RT Act of 2009 were not followed. So thereafter, the Supreme Court had appreciated our submissions and had ordered and had set aside the interim order which was passed with the division bench of the Honorable High Court. And thereafter, it has also directed the division bench to take up the matter on merits. Pending the arguments on the merits, the exam shall stand postponed. We are not questioning the decision of the state. We are just saying the manner in which the change brought in is what we have grievance and we are questioning about. Ultimately, if they had followed the legislative procedure, that is the previous publication and also with the rules, the rules, as you know, it has to be tabled before both the houses of the Legislative Assembly. We may not have we have no grievances. But however, that on the fag end of the academic year, how is that you propose to bring in a de novo change in the prevailing examination system only by way of government notification? So the methodology as adopted by the state is what we are questioning upon.
Before the SC's intervention, students had already commenced their exams. 2 papers were already held, and the rest have been postponed. The Department of School Education and Literacy has announced that exams scheduled for the following days will be postponed, and regular classes will resume in the meantime. Petitioners emphasized that the state government had only obtained an interim order from the division bench, similar to the situation the previous year. The government defended the exams, labeling them as summative assessments aimed at preparing students for future exams. But the court remained skeptical, saying that the name change did not change the exam's fundamental nature. Another issue was that concerning whether the exam marks would impact final grades. Despite the government's affirmation, the court expressed concerns about potential violations of existing rules. For students who have already given 2 of their exams, this sudden change disrupts their momentum and leaves them uncertain. Parents are frustrated over the lack of clarity and consistency in the decision-making process. Teachers too found themselves caught in the crossfire of legal battles and changing directives. It makes it difficult to plan and execute assessments effectively. After a series of yes and no's, what lies ahead still remains uncertain. This is Mandira and you're watching India Today SoSouth.